Hello, my name is Zachary Mercier, and today I will be doing my presentation on judicial decisions. First, we must start with the other sources of law. There are several different sources of law within each of the 51 systems. There are 7 sources of law that will be discussed in detail and considered primary sources of law. First off, we'll start with constitutions. Constitutions can be split into two in our country, the U.S. and state constitutions. The United States Constitution defines the structure of the national government and dictates the scope and limitations of its power. The Constitution is known as the supreme law of the land, and other laws are measured against it. The application of the articles and amendments of the constitutions are comprised as constitutional law. In addition to the United States Constitution, each state has its own constitution and therefore its own body of constitutional law as well. State constitutions resemble the federal constitution in that they outline the state government's structure of legislative, executive, and judicial branches, as well as contain a Bill of Rights. There are various ways state constitutions differ from the federal constitution. Often, state constitutions are much longer and more detailed than the federal constitution. State constitutions focus more on limiting rather than granting power, since its general authority has already been established. As a result, the Constitution of Alabama is 600 pages, whereas the federal Constitution can be easily read in one sitting front to back. The details in state constitutions are not particularly constitutional in nature. They often address topics unique to the state. The federal Constitution can only be amended through a lengthy process designed to limit changes to this fundamental document. As a result, it has only been amended 17 times since the adoption of the Bill of Rights in 1791. State constitutions are more open to amendments. Amendments can be proposed by legislature, a constitutional commission, or citizens petition, and can be accepted by referendum. For example, the Constitution of Massachusetts has been amended 120 times. The Constitution of Georgia has been replaced altogether as many as 10 times. The next topic will be treaties. International agreements are formal understandings or commitments between two or more countries. As an agreement between two countries is called bilateral, while an agreement between several countries is called multilateral. The countries bound by an international agreement are generally referred to as states parties. Under, under international law, a treaty is any legal binding agreement between states. A treaty can be called a convention, a protocol, a pact, and even an accord. It is the content of the agreement, not the name, which makes a treaty. Thus, the Geneva Protocol and the Biological Weapons Convention are both treaties, even though neither has the word treaty in its name. Under U.S. law, a treaty is specifically a legal binding agreement between countries that requires ratification and the advice and consent of the Senate. All other agreements are called executive agreements, but nonetheless legally binding for the U.S. under international law. A treaty is negotiated by a group of countries, either through an organization set up for a specific purpose or through an existing body such as the United Nations Council for Disarmament. The negotiation process may take several years, depending on the topic of the treaty and the number of countries participating. After negotiations are finished, the treaty is signed by representatives of the governments involved. The terms may require that the treaty may be ratified as well as signed before it becomes a legally binding document. A government ratifies a treaty by depositing an instrument of ratification at a location specified in the treaty. The instrument of ratification is a document containing a formal confirmation that the government consents to the terms of the treaty. The ratification process varies according to the law and constitutions of each country. In the U.S., the President can ratify a treaty only after getting the advice and consent of two-thirds of the Senate. Next will be the statutes. Statutes are laws passed by legislative bodies and usually arranged by subject. Statutes are the best way to start researching primary legal sources. Most jurisdictions publish an official statute series or set. These official versions contain very few extra research tools other than an index and select tables. Annotated statutes are commercial publications of the statutes with references to other sources of law. Most often, case law, which defines, broadens, narrows the scope of the statute. Annotations also provide references to law review articles, ALRs, treaties, and other research references. The next will be administrative rules and decisions. Administrative law is the body of primary law created by administrative agencies of the United States government, which are part of the executive branch. Administrative law consists of rules and regulations that govern activities, orders and decisions from administrative courts that are created to resolve disputes and arise under rule and regulation, and presidential proclamations and executive orders. Many areas of law are heavily regulated. Congress gives agencies the power to create administrative law through enabling statutes, which create agencies and specify their powers. When researching administrative law, it's often helpful to begin by reviewing the enabling statute in order to better understand the agency's purpose and scope of activities. Agencies are limited to the power delegated to them through their enabling statutes. However, in reviewing agencies' actions, courts will usually give agencies wide latitude in carrying out their mission, and will defer to agency unless it acted in arbitrary and capricious manner. Administrative agencies create regulations or rules that function like legislation. Like statutes, regulations are published both chronologically and by subject. Under the terms of Administrative Procedure Act, agencies must first give notice of proposed rulemaking by publication in Federal Register, along with a time period during which interested parties may submit comments to the agency and recommend changes to the text of the proposed rule. After the comment period expires, the final rule then is proposed in the Federal Register, along with its effective date. In proposed and final rule published in the Federal Register, there is a supplementary information section that explains the purpose of the rule, and in the case of the final rule, summaries of comments received during the comment period that indicate any changes that were made. Now we're moving to executive orders. An executive order is a signed, written, and published directive from the President of the United States that manages operations of the federal government. They are numbered consecutively, so executive orders may be referenced by their assigned number or their topic. Other presidential documents are sometimes similar to executive orders in their formalities, and issue, but they have different purposes. For example, proclamations, which are only signed and numbered consecutively, communicate information on holidays, commemorations, federal observation, and trade. Administrative orders are not numbered but are still signed and are used to manage administrative matters of the federal government. All three of these documents are published in the Federal Register, the daily journal of the federal government that is published to inform public of the federal regulations and actions. The executive orders are also cataloged by the National Archives as official documents produced by federal government. Both executive orders and proclamations may have the force of law, much like regulations issued by the federal agencies, so they are codified under Title III of the Code of Federal Regulations, which is a formal collection of all the rules and regulations issued by the executive branch and other federal agencies. Executive orders are not legislation. They require no approval from Congress, and Congress cannot simply overturn them. Congress may pass legislation that makes it difficult to pass the law, or even impossible to carry out the order, such as removing funding. Only a sitting president may overturn an existing executive order by issuing another executive order to that effect. The executive orders have a 5-step process in their format. First, the heading, which includes the date and the number of the order, the title, which typically indicates what the order concerns, an introduction stating that by the power invested in the president, this law can be passed, and then the body of the order, which will have more details of the order, and depending, it can be a long or short, depending on what the order is about, and then finally a signature from the United States of America. Next is the private law. The private law governs relationships between individuals, such as contracts and laws of obligation. In countries where it is known as common law, it also includes contracts made between governments and individuals. The opposite would be public law. Public law is a law governing relations between individuals such as citizens and companies and the state. Private law includes civil law, such as contracts, laws of tort, property law, labor law, commercial law, corporation law, and competition law. An example of private law would be smoking. Smoking is an example of both private and public law. The first aspect of smoking is indoor smoking, which is considered prohibited due to public law and its health implications. People have found a way to work around this public law by creating private law that excludes government intervention. They can form an agreement between the member and the property owner, which would allow people to smoke indoors. This is just one example of private law that has been used in the United States. Now, for the remainder of the time, I'll be going through judicial decisions. Judicial decisions constitute one of the most important sources of legal authority, along with legislative and regulatory enactments in our common law system. Even statutes must be read in conjunction with case law, which construe the correct application of legislation. First, there are 3 types of judicial decisions. The first one we'll be going through is interpretation. Interpretation breaks down into several different parts as well. The first one we're going through is literalism. This is the most literal interpretation of the decision process. This is the simplest breakdown in interpretation as well. The answers will be displayed word for word in the Constitution, is one way literalism is put. There does not need to be any other documents used as support other than the Constitution. The interpreter must put 100% of their faith in the Constitution's power to provide the answer. We'll go through the advantages and disadvantages. Advantages, first off, is this form of interpretation is beneficial because it removes the judge's predispositions. They must follow the law and only the law. This takes out all bias and opinion from the conversation. Now the many disadvantages. The problem with this form of interpretation is that the framer might have had their own idea of what they wanted to understand or how they wanted to understand the Constitution. There are many inconsistent outcomes when it comes to literal interpretation. There is a lack of words and meaning for the language that is used in the Constitution. Some of the words have different meanings, and this will cause a serious problem. The interpreter can use their own meanings of the words to sway a different outcome in the trial or jury decision. The final problem with literalism is when it comes to the value of the Constitution. They have if they have some conflicting values, this will cause some confusion for the interpreter. A literalist approach will offer no help when it comes to resolving this issue. The next one we will go through is original intent. The second form of interpretation revolves around the historical basis and intent of the framers. To understand the original intent, one must first understand what the law is supposed to mean and the purpose of the law. The biggest problem arises when people create their own interpretations for their own benefit. Some advantages would be that this form would be if someone decided to deviate from the intent of the framer. It would change the nature of the Constitution, so they would not be able to deviate because that would change the whole nature. The next factor would be to solidify the solidarity of this form. The law cannot change according to the interpretation of the judge. This removes bias, which is nice. Each interpreter can have an initial starting point when they come to unanticipated circumstances. They can start by deriving principles and applying them to the circumstances to see if that can resolve the situation. The disadvantages would include a problem with original intent, where there is lack of complete records, because there's no historic transcript of the Constitutional Convention debate. This would mean that there is no real way to understand the intent of the framer. Another subdivision would be which framer we would try to follow and understand. It would be very difficult to find who the framer is in the first place. Most of the sections of the Constitution were framed by many people. Each individual had their own interpretation and true intent. The true intent is impossible to fully understand and usually involves many inferences and assumptions when one is trying to decide true intent. The next form would be doctrinal approach. This involves following precedent. It involves the principle of stare decisis, which means let the decision stand. This understanding is the fact that new cases should be decided the same way as old cases. According to a doctrinal approach, the interpreter needs to follow precedent if there are similar facts in a previous case. This is to keep the consistency between the consideration of each case. This helps each legislator make laws stable and predictable, so many people have a general idea as to what to expect from judges based off previous cases. The advantages for this form of interpretation include the ability to adopt a principle and apply it to cases on a broad spectrum. This tries to attempt an internal consistency with the judge's decisions. It is very effective to keep the consistency and continuity of law. The disadvantages include that the doctrinal approach would be at the size and diversity of each case. After looking for precedent for one side of the case, there will be similar precedent for the other side of the argument. This is one of the most common forms of incorporation, which can be a problem in the courtroom. Justices can always decide facts of a case that are different from the precedent. This is a problem because there are no guidelines for following precedent. Next will be the competing interests. It is important to follow a certain balance in any case. Balancing one interest against another is a very important part of making a decision on a case. The sensibility of the important aspects is to take into consideration. Sensibility is one of the important aspects to take into consideration. The values of the case must be weighed to understand which deserves more protection. They must recognize the implications of each case and their decision. This form is problematic because it messes with consistency of the case. There is less weight to be carried in the consideration of precedent. There is also no standard means of making decisions, so it is up to the judge to make that decision. It also is up to the subjective opinion of the judge. Structuralism is the next part, and I would be just listing the disadvantages. So this form is more abstract, is more of an abstract approach, and it means it is less accurate. There is more chances of multiple interpretations which could create more confusion on any matter. It is subjective, so therefore influenced by the user or the interpreter. The second part of judges' decisions or judicial decisions is common law. Common law, at its simplest definition, is a court-created law. Common law arises when the courts are called upon to resolve disputes for which there is no statute or other source of law establishing a rule. Common law originated from early English history. William the Conqueror and his successors attempted to unite the country by dispatching royal judges to hold court in each of the cities. This practice serves to replace the varying customs and rules of each locality with a uniform system of laws. Over time, the law evolved as more and more disputes were heard by the judges. After the American colonies won their freedom, they adopted the large body of English common law. Common law has no statutory basis. Judges establish common law through written opinions that are binding on future decisions of lower courts in the same jurisdiction. Broad areas of law, most notably relating to property, contracts and torts, are traditionally part of common law. These areas of the law are mostly within the jurisdiction of states, and thus state courts are primary sources of common law. Thus, common law is used to fill in gaps. Common law changes over time, and at this time, and each state has its own common law on many topics. The area of federal common law is primarily limited to federal issues that have not been addressed by the statute. Common law versus civil law. In common law countries, case law in the form of published jurisdiction opinions is of primary importance, whereas in civil law systems, codified statutes predominate. But these divisions are not as clear-cut as they might seem. In fact, many countries use mix of features from common and civil law systems. Understanding the difference between these systems first requires an understanding of their historical upbringings. In civil law, judges are often described as investigators. They generally take the lead in the proceedings by bringing charges, establishing facts through witnesses, examination, and applying remedies found in legal codes. Lawyers still represent the interests of the client in the civil proceedings, but have a less central role. As in common law systems, however, their tasks commonly include advising clients on points of law and preparing legal pleading for filing with the court. But the importance of oral argument in court presentation and active lawyering in court are diminished when compared to a common law system. In addition, non-litigation legal tasks such as preparation and contract drafting may be left to quasi-legal professionals who serve businesses and private individuals, and who may not have a post-university legal education or be licensed to practice before courts. In contrast, in a common law country, lawyers make presentations to the judge and examine witnesses themselves. The proceedings are then referred to by the judge, who has somewhat greater flexibility in a civil law system, to fashion an appropriate remedy at the conclusion of the case. In these cases, lawyers stand before the court and attempt to persuade others on points of law and fact, and maintain a very active role in legal proceedings. And unlike certain civil justice jurisdictions, in common law countries such as the United States, it is prohibited for anyone other than a fully licensed lawyer to prepare legal documents of any kind for another person or entity. This is the province of lawyers alone. The final part would be judicial review. Courts have the ability to make law through their authority to interpret the meaning of any other sources of law. Under the power of judicial review, a judge may render a legal rule unenforceable by declaring it in conflict with constitutional Similarly, higher courts may decide that lower courts' decisions are invalid. The principle of judicial review appeared in the Federalist Papers, No. 78, authored by Alexander Hamilton. Hamilton first disposed the idea that legislators should be left to enforce Constitution upon themselves. Hamilton's opinion that a Constitution is, in fact, and must be regarded by the judges as a fundamental law, is therefore belongs to them to ascertain its meaning, as well as the meaning of a particular act proceeding from the legislative body. If there should happen to be an irreconcilable variance between the two, that which has the superior obligation and validity ought, of course, to be preferred, or in other words, the Constitution ought to be preferred to the statute, where the will of the legislator declared in the statute stands in opposition to that of the people declared in the Constitution, the judges ought to be governed by the latter rather than the former. He came out and explicitly argued for the power of judicial review. Whenever a particular statute contravenes the Constitution, it will be the duty of judicial tribunals to adhere to the latter and disregard the former. There were a lot of different cases impacted by judicial review. The first and the most prominent of judicial review would be Marbury versus Madison. Marbury versus Madison was one of the first cases that brought about judicial review. The next cases that will be explained were also branches off from that case and were only possible because of judicial review. In Brown v. Board of Education in 1954, the Supreme Court struck down state laws establishing separate public schools for black and white students on the grounds that they violated the Equal Protection Clause of the 14th Amendment. In Gideon v. Wainwright in 1963, the Supreme Court forced states to provide counsel in criminal cases for indigent defendants who were being tried for commission of a felony and could not afford their own counsel. In Loving v. Virginia, 1967, the Supreme Court struck down a Virginia statute that prohibited interracial marriage, also on equal protection grounds. In Brandenburg v. Ohio, 1969, the Supreme Court ruled that the state criminal laws that punish people for incitement could not be applied unless the speech in question was intended to and likely to cause people to engage in imminent lawless action. In Furman v. Georgia, 1972, the Supreme Court temporarily halted the death penalty in the United States by ruling that the state death penalty statutes were not applied consistently or fairly enough to pass muster under the Eighth Amendment. In Roe v. Wade, 1973, the Supreme Court struck down laws that made abortion illegal. Through Roe and many later cases have walked a tight line Though Roe and many later cases have walked a tight line in determining exactly how far the right to choose an abortion extends, the basic idea of that right to choose an abortion is protected as part of the right to privacy and still stands as a law of the land. In Buckley versus Valeo in 1976, the Supreme Court struck down spending limits on individuals or groups who wish to use their own money to promote a political candidate or message on First Amendment grounds. In Regents of University of California versus Bake, 1978, Supreme Court struck down certain types of race-based preferences in state college admissions as violating the Equal Protection Clause. In Lawrence v. Texas, the Supreme Court struck down sodomy laws in 14 states, making same-sex sexual activity legal in every U.S. state. In Citizens United versus Federal Election Commission, 2010, the Supreme Court struck down a federal election law that restricted spending on election advertising by corporations and other associations. In National Federation of Independent Business versus Sebelius, 2012, the Obamacare decision was famous for upholding most of the Patent Protection and Affordable Care Act. However, it struck down an element of that law and threatened to withhold Medicare funding from states that did not cooperate with the law on grounds that it was unconstitutional violation of state sovereignty. Though some of these decisions remain controversial, none of these decisions would be possible without judicial review. In every case, and countless others, the court used its power of judicial review to declare that an act by a federal state or state government was null and void because it contradicted a constitutional provision. It is this power that truly makes the courts a co-equal branch of government. With the executive and legislative branches, it allows it to defend the rights of the people against potential intrusions by other branches. Thank you.